And good afternoon, everyone. Now, I'm not a solicitor. I'm an ergonomist. So I'm an ergonomist who writes expert witness reports when instructed by solicitors. But the picture that I'll present may not be entirely accurate in a legal sense. So please, if there are solicitors out there, please don't send in too many horrible questions as to what I've got wrong here. But I'm looking at it from the perspective of an ergonomist who's trying to evaluate a workplace and a work activity that has been suggested to have caused some injury to a worker. What I'm going to say or advise may appear to place a fairly heavy administrative burden on the employer, particularly with respect to record keeping and so forth. But I would say that it's really just good practice. The extent to which you might want to follow my advice is, of course, up to you, and it's probably the case that the full benefits of following it would only become evident if you actually ended up in a litigation situation. But you can't avoid litigation. If it's going to happen, it's going to happen. What you have to do is to try to run your ship so that you can reduce the risks of being found negligent by a court. Unfortunately, in my experience, there are many companies that are sailing far too close to the wind in this regard. What you can do, though, is improve your chances of successfully defending any claim that may be made against you. Of course, I'm talking about you as being an employer rather than the injured person. But as an ergonomist, an independent ergonomist, of course, I quite often act or receive instructions from solicitors representing the injured person, the claimant. So how do these things start anyway? Why does someone decide to sue their employer for damages? Because they feel they've got an injury that they understand or they believe is caused by their work activity. Well, in the first case, it might be that the worker begins to notice that they've got some pain whilst they're working, and eventually, and it's difficult for them to know exactly when, but eventually that pain becomes so bad or so chronic that they go to the doctor, and they're told that they have perhaps some sort of musculoskeletal injury or some other injury, but they're also possibly given the impression that it may be work-related. Now, the doctor might not mean that it's been caused by the work, but the use of the term work-related injury tends to imply to most sufferers that the work has caused it. But what we really might be meaning is just that the work has a relevance to the injury, and that when you're doing the work activity, you feel the symptoms. But that doesn't necessarily mean that the work has caused them. But we'll perhaps come back to that a bit later. Now, when the injured person has been to the doctor or come back from the doctor, they may or they may not tell their employer that they've been, or indeed that what the doctor has said. And quite often the employer is left in ignorance, indeed, of the situation developing. But if they do tell their employer, they may feel that the employer doesn't take them seriously, or that they're not making changes to the work activity to address their complaint. And it's at that stage that the person perhaps starts to think that they'll take their employer to court. And of course, if they do think that way anyway, they will have to go and find a solicitor. Now, these days there are plenty online, but they may just go up to the high street and find a solicitor who can help them. And that solicitor will arrange for the injured person to go to a medical expert, to a consultant or a specialist in a particular musculoskeletal. This is the area that I work in, so I'm going to focus on that area. But they'll get the injured person to visit a medical expert in some sort of orthopedic or rheumatology discipline. And that medical expert will assess the injury, and they'll provide a report and a diagnosis to the solicitors so that they can see whether or not to take this matter further. The medical expert, will often also provide an opinion as to whether or not the injury might be work-related. But of course, that expert is in all cases, will never have seen the actual work activity or the workplace. After that, if the solicitor thinks there's a reasonable case to pursue, the employer will then receive a letter from that solicitor, and that letter will set out the reasons why it is considered that the work has caused the claimant's injury. The letter will probably ask the employer for copies of relevant risk assessments, training records, and evidence of pay and overtime that the employer might hold. And as an employer, you'll also be asked to immediately pass on that letter to your insurers. On receipt of that letter, your insurers will then appoint solicitors to look after this matter on their behalf, and indeed, of course, on your behalf. And it's then that those solicitors might well contact an ergonomist, but we'll come back to that in a little while as well. But in a litigation case, you really have to consider or to prove three issues. And these are normally causation, liability, and foreseeability. In general terms, causation is going to be largely a matter for the medics. They're looking to see, firstly, whether actually you've got an injury, whether the injured person has got an injury, and whether or not they can give a diagnosis to it, and whether or not it might be caused by the type of work activity the claimant says that they carried out. You've also got to be able to prove liability, and that is usually a matter for the technical experts. And we're looking at whether or not the employer has actually done all that they were required to do under things like regulations and codes of practice and so forth. You also have to show that there was foreseeability. And this, in fact, was something that perhaps the employer ought to have realised, that this work activity might present a risk for an individual doing that job. And this is a matter for the technical expert to consider, but also for the employer. I can always remember many, many years ago a lecturer stressing to me, or stressing to the class, that there was a need for you to get up and go out and have a look at the workplace. And the expression that she used was an acronym. It was GOYA, G-O-Y-A. And it stands, for those of you that don't know, it stands for get off your bottom. Go out there and have a look at the workplace, because a lot of these problems which end up in litigation are there for all to see. They are foreseeable, and if the injured person can prove foreseeability, then they are a good way towards proving their case. The sorts of things I mean, let's have a look at foreseeability. The sorts of things I mean are things like staff complaints. Have you got on record formal complaints by people in a particular department who are reporting a trend in the type of injury or problem that they face? Similarly with sickness records that you can get summaries of from the Occupational Health Department or whoever, but you can find out whether there is a trend of people being away who carry out a particular work activity. And of course, I hope you've got your risk assessments, which will indeed usually show you where you've got anything more than a trivial risk associated with the work activity. And provided these have been followed up, then hopefully you will be able to identify whether there is any foreseeable risk associated with these work activities. And if you do your GOYA bit and you go and have a walk around the workplace, you will probably see some little things that ought to tell you something is wrong. Something like this, which I don't think takes an ergonomist or any sort of expert to tell you that this isn't a workplace that is suitable for, certainly not for intensive computer work, it's simply from the cramped space. And if you see these sorts of workstations, then really it is a case of you ought to be trying to do something about them to prevent that person who's working there from suffering some sort of injury. Now, getting back to the litigation case specifically, if the court thinks that it's appropriate and helpful to the case, then they might allow, because it isn't always the case, but they might allow the appointment of a technical expert. Now, the technical expert isn't always an ergonomist. It could be a forensic engineer, or it could be a health and safety specialist. But obviously, I'm going to be looking at it from the ergonomist perspective. And it's possible that the court will decide that the case should be examined by a single joint expert. So instead of each party, the claimant and the defendant, being able to appoint their own ergonomist, the court might decide that a single joint expert be appointed. And the idea there being that that person will report directly to the court, having taken evidence from both sides. But more normally, perhaps these days, even since the various reforms that there have been in the civil justice area, it's still, in my experience, more common to have separate experts instructed by each side. They still have to be independent, they still have to be objective, but they are appointed, one by the claimant and one by the defendant. And they are required to produce a report on the merits or otherwise of the individual's case. But of course, before you can produce a report, the ergonomist will have to make a site visit, and at that visit, which probably takes generally between an hour and 2 hours, they are going to be looking at the work equipment, the work activities, and these are examined in relation to the work schedule or the workload that that individual had to cope with. Now, in addition to the ergonomist being there, the claimant would normally attend that meeting in order to be able to explain exactly how they worked at that workplace and whether or not the workplace had changed in any way. And the ergonomist will be looking for a number of indicators in order to identify primarily whether or not the biomechanics of the work task, the requirements of the work task, can be related to the injuries. And in that context, they're essentially helping the medical expert in the matter of causation. The ergonomist as well will want to see those risk assessments that you produced, and this is something I'll come on to in just a moment, because this is where we often see so many of the problems for the employer, for the defendant. Not only assessments, but also standard operating procedures and training records. They are often not of a sufficient detail to be able to support the employer's position. And if that is the case, or indeed if the work activity is shown to be inappropriate, then this of course will all help the claimant's position. And I wouldn't want to suggest that that wouldn't be the right way to go. If the work has caused the person's injuries, then so be it. They probably, or they may well, deserve some sort of compensation. But the ergonomists, if one on either side, they'll both produce detailed reports on their work and put forward their parties' views on the situation. And they would then be asked, the two ergonomists would then be asked subsequently to have a joint discussion and to produce a single joint statement which would be put to the court. And this statement hopefully narrows the issues between the parties. The report that goes forward is sometimes referred to as a liability report, since it has to include a consideration of whether or not the defendant complied with the relevant regulations and codes of practice. And if we have a look at some of these issues, in liability we have the regulations, the ACOPs, the guidelines, and although SOPs aren't a legal requirement, if you've got SOPs, standard operating procedures, that have or haven't been followed, then that will give some indication to the court as to where the liability lies. And my advice to everybody would be to do whatever these documents say you should do. For instance, with the regulations, we know for display screen equipment, we know that training is required, specifically in the sort of areas that are relevant to use of computers. Now, in litigation, in cases that I've seen, quite often this document is produced, which is very useful, but it is insufficient as your efforts towards providing training. It can contribute, you can provide that document, and it is, as I say, very useful, but it is not a sufficient activity or in itself to represent DSE training. You need to be much more hands-on and provide one-to-one or classroom training, or perhaps a DVD or whatever. But to provide just that document, which has happened in many of the cases that I've been involved in, does not go down well in the court, however useful that document might be. With ACOPS and guidance, I think we all know in the guidance to the UK anyway, the UK regulations on display screen equipment, the guidance says that the work chair shall allow the user a comfortable position. Now, if you'd done your Goya bit, or in this case, if the person had done their Goya bit, they would have noticed that this work chair is probably not providing a comfortable work situation for that individual who had decided to put a rather large foam rubber support on their chair. And it doesn't take an ergonomist or any specialist to be able to see that that chair is clearly not providing the person with the sort of support that they need. And as an employer, you would be expected to not just pat the person on the back and say, oh, that's very good ingenuity, well done for sorting that problem out. You should be trying to provide them with a far better, far more appropriate chair or system to support them while they're carrying out their work. If you've got standard operating procedures, SOPs, and your SOP in this case, which was another litigation case, says that you shall only put 15 kilograms worth of load into your archive boxes, then that is what you should do, even if there's a gap at the top of the box. But what normally happens is that people fill these to the brim because they want to save on the space. One can understand this, but if it ends up in litigation, you're going to be hard-pressed to defend this position, because a full archive box of that sort of size probably weighs 25-30 kilos. And if, as in archive rooms, the shelving is often above shoulder height, if you're lifting to shoulder or above height with 25-30 kilos, it is clearly foreseeable that for some people this will present a risk of injury. So foreseeability and liability are significant issues which you can have a look at well before we get to the stage of it being a litigious situation. I want to just look at a couple of other cases where documentation has been unclear in the case, or indeed incomplete. And I know we're all busy, and it's very difficult to make sure that all our documentation is up to speed. And as I said right at the beginning, it's going to appear to be a rather large administrative burden. But if you do end up in court, having documentation that is unclear or incomplete does not sit well with the judge, and it will be hard to defend a case where this is the case. And in these two examples that I'm going to show, I think you'll be quite evident as to why these are not adequate pieces of documentation. And I hope that you won't come across ones that are quite as bad as these. This is an occupational health record for an individual who reported to the Occupational Health Department a few times during, it looks like, 2008. And initially they had sciatic nerve problems, and then a couple of months later, I think we can see in March that year, they had sciatic pain was recorded again, and then again a couple of months later, curiously, the problem they were presenting with was arm pain. Now, nothing wrong with that, and but the Occupational Health Department, as is quite common, these are the questions which are often asked of them. They were asked to fill this in relation to this individual to see whether or not they should be returning to work, having got these problems. And the form asked, please answer the following questions. What is the current status of physical and psychological fitness of the individual? And in this case, the occupational health, I believe it was the occupational health medic, but it, as you'll see later, I'm not sure, but they said that the current status was unknown. And I'm not too happy with that response from an occupational health department when that is really the service that they should be providing, is to know what the status of the health is. Second question was, what is the anticipated length of further absence, or is there a return to work date? Well, this seems a little bit clearer, return to work in 7 days, although how they make that judgment when they don't know what the physical or psychological fitness of the individual is, I have some problem with that. The question is also asked, what has the GP diagnosed? Well, the GP diagnosed exacerbation, and the occupational health department doesn't seem to be helping with that, because is it an exacerbation of the spinal problem, the sciatic problem, or is it of the arm pain that they were presenting with? So a lot of confusion, it's unclear as to what we're doing. It's really not a very helpful document, this. And finally, any other recommendations? And the occupational health person had put wait and see, which again I find to be rather unprofessional, because I don't see either what you can interpret that to mean, or that it is indeed in any way helpful. And finally, on the bottom, the document was neither signed nor dated. And one thing that is very important in litigation is that you be able to form a chronology of the events that happened throughout that person's employment during the material period, during the time when they were exposed to the work activity. So on a different case, I would urge, from the documentation that I've got for this one, I would urge that you pay attention to the comments that you see in your risk assessments. If you don't, you do become a hostage to fortune in some ways, or misfortune. Forgive the scruffiness of this, but this is just scanned from the actual self-assessment questionnaire for a DSE assessment. And the date is given there, if you notice, of 2004, and that will become significant later on. At section 14 of this questionnaire, it says health matters. Do you get aches, pains, pins and needles, tingling sensations or numbness which may be related to work? And the person has ringed the yes answer, I do. And they've written in back. So they're getting some sort of aches and pains or whatever in their back. It's not clear exactly what problem they've got, but they've identified it quite clearly. The next question about headaches, eye fatigue, they've said no. The third question, do you have problems with mental fatigue or stress which may be related to work? And they've clearly ringed the yes. Now the company's own form there says any answers to the above questions that indicate a problem, this assessment should be copied to the safety officer, and the name of the safety officer has been blacked out. But nothing was done in this case. In section 6 of that same assessment questionnaire, it says, are the user's tasks organized so that display screen work is alternated with other activities? And they clearly said, no, it isn't. And that isn't always a problem if you get sufficient breaks. But under B, if no, are specific work breaks provided and enforced away from the display screens? And the individual in this case has been very, well, can you be very emphatic? Has been emphatic. No, 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 they have indicated. Now, I think to anyone, this would suggest that you need to fairly expeditiously have a look at this person in their workplace and try and sort out what it is that might be causing their particularly back problems, but maybe other problems. They're stressed as well, and so forth. Well, this matter did in fact eventually get to HR, and they posed a question to the Occupational Health Department. What can we do to help this person? And the Occupational Health Department's response was, we will get an assessment and offer advice. Now this is a different Occupational Health Department to the last cases I was discussing, and I think in this case that's a a reasonable view. They didn't have perhaps the expertise within the occupational health department. They're going to get one done, and they'll then offer advice. Unfortunately, there was a bit of a time delay even before HR got involved. And eventually, the HSE became involved, and a specialist inspector went and visited, had a look at all the documents, had a look at the problem, obviously, and wrote a letter to the defendant. And in that letter, they noted that an ergonomics consultant's report was sought in May 2006. Now, you may remember that it was in 2004 that this person had filled in their questionnaire and identified all these problems. So it was another 2 years before that assessment that HR had requested was actually undertaken. And then eventually the HSE specialist inspector attended, but by that time, they say, of my visit, 18 months later, sometime in 2007, none of the recommendations had yet been implemented. So this is some 3.5 years after the person had reported in their self-assessment questionnaire that they had quite significant problems, that still nothing had been done. And it's perhaps not surprising that this case did end up in litigation, and the person, I would have said, had a very reasonable case to pursue against the employer. And it really just, I think, illustrates the need for having good documentation that is properly followed up. Indeed, in conclusion, if you want to be able to defend personal injury claims, you must do what you're required to do what you say you will do and do it properly, record what you've done and when you did it. And some actions that you can take to reduce the risk of litigation, which you can take these well before you get into a situation of litigation, is to design the job according to ergonomics principles in the first place. Undertake relevant pre-employment screening and gather information that's relevant to the job so that you know whether this person is going to have any vulnerability to the sort of work they're going to carry out. Carry out the risk assessments. Don't wait until the person is injured, but make these interventions if they're necessary. But if the person does become injured, then certainly do a reassessment. And in consequence, provide the necessary treatment and/or actions. Establish an appropriate return to work program. We see so many occasions where the person goes straight back to the same level of and intensity of working, and it really, in many cases, needs a staged or phased return to work program. And you may need to consider health surveillance. And I think on that note, what I will do is hand back to Catherine to see if she can filter out some easy questions for me and say thank you very much for attending.
Thank you, John. I'm not sure that I can find some easy questions for you, but I will certainly give you what's come through. I know we don't have an awful lot of time, so we'll try and sort of rattle through them. I have one here that says, what is the role that the psychological factors play in a litigation case? Are they considered by ergonomists in their reports and in their assessment?
A very good question. Normally we would back that one back to the medics and say you need to get a psychiatric report on the person in that respect. But in some of the ways, it is quite obvious that there are going to be psychosocial issues associated with the work activity, whether there is a problem between the injured person and the line management, whether or not there's a work pressure which is unreasonable, and all of these sorts of psychological issues, psychosocial issues, also do exacerbate or can exacerbate a musculoskeletal problem. And so yes, these are things that in many ways we will address to see whether or not they are a factor in the causation or the contribution to the injury. But really, that is a matter which we would also be putting back to the medics to see whether they would support the fact that the degree of psychosocial problems might in fact be relevant in this case.
Okay, thank you for that. This might be quite a quick one, and it may not be appropriate. Is the same process in place in Scotland, and I suppose the rest of the United Kingdom, as it is in England?
Largely, the way in which the courts work in Scotland is slightly different. You have a pursuer and a defender, I think, rather than a claimant and a defendant. But largely the issue, certainly the HSE documentation and guidance and regulations are still appropriate there. And so you're still working to the same criteria and the same requirements, the same level of need. But the way in which the court system operates is quite different. But the requirements in terms of whether or not somebody has been injured and your criteria for assessing that are just the same.
Okay. This is one that's really quite a sort of DSE orientated, and I think probably it's around hot desking. And I think probably, have you got any experience of sort of risk assessments of hot desking in litigation? You know, are people looking for specific risk assessments for hot desking areas? Is there any guidance you can give us with complaints, litigation and hot desking?
With all these litigation cases, they are very specific, and yes, eventually, if there was enough case law, I suppose one could come up with guidance as to how to deal with these things. But I suppose my simple answer to that question is no, there isn't really any evidence or guidance that comes directly out of the sort of litigation that I've been involved with so far in relation to hot desking. Certainly for those cases where hot desking has been an issue, then it has been, or we certainly examined it, but it's never none of the aspects which contribute to an injury are the sole, or rarely are they the sole issue which has caused the problem. So hot desking may be one factor. It may be the fact that the person is under a lot of work pressure, that the type of work is inappropriate to a hot desking situation. It can be a whole host of things, but the risk assessments that one ought to do in those situations ought to be the same, ought to cover the same issues as any risk assessment, but in the knowledge that your workplace or your workstation is a hot desking one. And in those situations, you should be looking for much more adjustability in the workstation, so that any individual there hopefully has also been trained, but they know how to, and they can adjust that workstation to suit their needs for however short a period it is that they're going to be working there.
Okay, I think unfortunately time has run out on us here, so I think we may need to just gather some other questions that are coming in that we'll try and put up on the website and try and put some sort of answers on that. So thank you, John. I think I will let you off the hook there at the moment, but I will be forwarding the questions to you for some thought. So really, I think thank you for that.